Good morning, everyone. I'm Doug Olin, and I'm going to speak this morning about 10 things to keep in mind with respect to retirement assets. And we have, the first thing I want to talk about is something of a new development, but the law was enacted about a year ago, and it seems like every year at this time of year, we were waiting and wondering if we were going to have an extension of the law that allowed us, or allowed our clients, to make qualified charitable distributions of up to $100,000 a year from their retirement accounts to charities. And last year, that law was finally extended permanently. So now we know that if our clients haven't done so yet, they can take advantage of the ability to roll over or transfer $100,000, which can qualify as part of their required minimum distribution, directly from a retirement account into a charitable organization. So that's something that we should be thinking about talking to our clients. Second, Roth conversions are still very much applicable, although I think based on the Trump proposal and the lowering of tax rates, it might not be something that I'm advising my clients to run out and do right now, only because if you wait until next year, we might have, instead of a top rate of 39.6% or even higher, we might have a top rate of 33%, and so it might make sense for clients that are thinking about converting their traditional accounts to Roth accounts to wait to do so until next year, or it might take more than a year for President Trump to get those rates lowered, but certainly something that's worth waiting for. The rest of my time, I'm really going to spend talking about beneficiary designations and what to keep in mind when naming beneficiaries for retirement plans. And I think one of the things that Rachel Zargami spoke about early on, I like to couch in terms of no benefit left behind, in that it's very important when dealing with retirement benefits or life insurance or employee benefits, anything that might pass outside of the will by beneficiary designation. I think it's really important to make sure that we keep track of those assets and coordinate them with the estate plan and build in to that beneficiary designation the proper provisions to make sure the assets go where they want to go. We don't want them going to that former spouse even after we're divorced. And so think about what your client's goals are and what they're trying to accomplish pursuant to their plan, and make sure we gather the benefits, including IRA and 401k assets, and make sure we coordinate them with the plan. And for retirement assets, if clients are charitably inclined, leaving those assets to a charity is often a great idea, because we can not only benefit the charity, but we can give them an asset that they won't have to pay income tax on, but our descendants or our other beneficiaries will likely have to pay income tax on them. To the extent we're not leaving those assets to charity, oftentimes the goal in the beneficiary designation is to try and stretch out the benefits for as long as possible. So if we're talking about a traditional account, those benefits are going to have to come out of that account eventually. And what we like to do, because they're growing inside the account on a tax-deferred basis, we would like to stretch out that deferral for as long as possible. So how can we do that? Well, the best way to do that is by naming a descendant as the designated beneficiary of the account. And if we have an 80-year-old client who names a 50-year-old child as the beneficiary, that child is going to take out distributions based on the child's life expectancy, which is at 50 is going to be 30, 35 years, something like that. And so the child can stretch out the deferral for those 35 years. If the client names a grandchild who's 20, Now we can stretch out, the grandchild can stretch out that benefit for 60 or 65 years. And so by determining who the designated beneficiary is, we have the ability to stretch out that tax deferral for as long as possible. And oftentimes, clients would like to pay as little tax early as they can. And so the more you can defer it, the better that fits in with the client's goals. But for a lot of clients, their estate plan isn't leaving assets outright to their descendants. Instead, they're leaving their assets in trust for descendants. And the reason they're doing that is because they want to take advantage of creditor protection, divorce protection, the child's too young, the child's a spendthrift, or those types of issues, or you want to do tax planning or generational planning. And so oftentimes clients will prefer to leave their assets in trust in order to take advantage of those protections. That's possible with a retirement benefit, but there are some hoops that you need to jump through because the tax law provides that you can only stretch out the benefits if you name an individual, someone that has a life expectancy. A trust alone does not have a life expectancy. So if you're naming a trust as a beneficiary and you want to get that stretch benefit, the trust has to be designed in a particular way in order for it to qualify as a see-through trust. A see-through trust allows us to then look at the beneficiary or beneficiaries of that trust and treat them as though they were named as the designated beneficiary, in which case we can use their life expectancy in order to stretch out the payments. If we can't see through the trust and use the beneficiary's life expectancy, the benefits are likely going to have to come out within 5 years of the death of the client. And so that's something it's very important to make sure that if you're planning to stretch, that the trust qualifies. For clients that are married that want to name their spouse as the beneficiary of the account, the spouse would qualify as a designated beneficiary and we could use her life expectancy or his life expectancy to stretch out the payments, although typically the stretch won't be all that significant for a surviving spouse. But more importantly, the surviving spouse has a special option provided to him or her in the tax code that allows the surviving spouse to roll over the account and make it his or her own. And there are really significant benefits to doing that because the surviving spouse then, if he or she is under 70 and a half, doesn't have to start taking any required minimum distributions until the surviving spouse gets to that point. Also, the surviving spouse can name his or her own beneficiaries, in which case we can stretch out then at the second death, at the death of the surviving spouse, naming either a descendant or a trust for descendants at that time. And that will give us the stretch payout at the second death. And so oftentimes that's the option that's chosen, or most often that's the option that's chosen by a surviving spouse. Rachel also talked about the reasons why we might want to have a trust for a surviving spouse, a second marriage situation, or fear of a subsequent marriage by the surviving spouse, or creditor protection issues, things like that. And so we can also use a trust for spouse as the beneficiary of a retirement plan. It used to be more common that we would think about this because before portability was allowed for the federal estate tax exemption, oftentimes we would need to think about using retirement plans when they were significant parts of clients' estates in order to fund the credit shelter trust, take advantage of the federal exemption. Without that need any longer, with the portability of that exemption available, we don't have to think about that. But there are still good reasons in these blended families or second marriages where the client will want to use a trust for spouse. A couple of things that are important to keep in mind in that case. One, the spouse loses the option to do the rollover, and that's typically the most valuable option. And so if a trust for spouse is named, even if it qualifies as a see-through trust, the spouse will still not be able to roll over the account and make it her own. It's in the trust. The trust owns the account. So that's lost. The other thing that's important to keep in mind is that both the retirement account and the trust would need to qualify for the marital deduction. And so lots of hoops that need to be jumped through in the drafting process to make sure that that arrangement works. A lot of clients are charitably inclined and want to benefit their descendants because their account might be so significant that they don't want to give it all to charity. But they do want to use part of it to benefit charity because it's a beneficial asset to leave to charity. It's important to keep in mind, though, that when you're using both a charity and individuals as beneficiaries, what the tax law says is that if you have even one beneficiary that is not an individual, so doesn't have a life expectancy, then it's treated as if there is no designated beneficiary at all, and you are not allowed to use the stretch payouts for anyone. Obviously, we don't care about using it for the charity, but most clients, if parts going $100,000 to charity, balance to descendants, most clients will want to use that stretch payout for the descendants. Well, the IRS provides an exception to the treatment that there would be no designated beneficiary, and that says that as long as you eliminate the non-individual beneficiaries by September 30th of the year after the year of death, then we can just look at who was the remaining beneficiary or beneficiaries at that time to determine if we have a designated beneficiary and can use the stretch payout. So in my example, $100,000 to charity, balance to descendants, as long as we pay out that charity by September 30th of the year after the year of death, we can use the stretch payout for the descendants or for the child, whoever that individual beneficiary is that's named. Regardless of who we name as beneficiary, it's very important to keep in mind who is going to pay the taxes. Most wills and revocable trusts have a tax clause in them, but state law provides a default if it's not covered by the governing instrument, by the will or by the revocable trust. And when it comes to blended families, it's very important to know who's paying the taxes. If the beneficiary on a retirement plan, and this would be the same for deferred comp or life insurance, some people like to have a $500,000 life insurance policy that's going to go to a nephew, but the rest of the estate is going to descendants. Well, who's paying the tax on that $500,000 that's going to the nephew? Is that the kids are going to pay the tax on it, and so it's going to be paid out of the residuary estate under the will and revocable trust? Or is that insurance policy or that retirement account going to pay its own taxes? Very important, and it makes a big difference, especially to the survivors who find out that they have to pay the taxes on assets that are going to someone else. So that might be exactly what the client wants, but very important to think about it ahead of time and make sure the plan provides what the client is thinking should happen. And then lastly, there are likely going to be changes on the horizon when it comes to retirement plans. When the provision first came into being that allowed Roth IRA accounts and allowed conversions from traditional accounts to Roth accounts, I remember sitting down with a client and talking about the benefits of conversion, and the client said, I'm not interested. I said, well, these Roth accounts, they seem to be pretty, I'm not interested. Well, we could hedge our bets, maybe you convert, I'm not interested. And so I said to him, I said, why, I mean, it seems like a really good idea. Why wouldn't you want to at least convert part of your account? He said, I don't trust the government. I don't trust that they will allow the system to stay the way it is. It sounds like it's too good to be true. And I said, all right, you know, I wasn't sure if I agreed with him, but if this law gets passed, or this proposed legislation that's bouncing around in Congress gets passed, that client is going to be exactly right, because what this legislation is going to do is, one, it's not going to allow conversions anymore. Two, it's going to require that account owners, Roth IRA account owners, who traditionally or under the current law don't have to take lifetime distributions, it's going to require that they take lifetime distributions just like they would from a traditional account. This legislation or proposed legislation is also going to require that inherited accounts be emptied within 5 years after the decedent's death, after the client's death. And that would apply not just to Roth accounts, but also to traditional accounts. They would eliminate, this legislation would eliminate the stretch benefit of retirement accounts. And so if we think about the reasons why clients might convert to a Roth IRA from a traditional, no lifetime distributions and stretch payouts are really at the top of the list. Add to that the fact that income tax rates are likely going down under the next administration. Conversion to a Roth IRA might become extremely less popular to proceed with. I'll leave you with one thing, which I did mention during the presentation, but that really applies, which is no benefit left behind. It's very important, and you all as advisors oftentimes can know more about the benefits that the client has, whether it's employee benefits, life insurance, retirement accounts. It's really important for all the advisors to be on the same page and for us to work together to make sure we coordinate these benefits so that they pass consistently with the client's wishes. And on that, I will thank you.